Let's get right into it. Welcome to The Explainer. Today, we're diving into a really fascinating case from the year 2000 that hit the Constitutional Court of South Africa. You know, we constantly hear about massive landmark rulings or flashy, high-profile trials, right? But we almost never get a peek behind the curtain to see how the legal machine actually operates. Like, who actually gets to stand in front of those top-tier judges, right? Well, this case, involving a guy named Johan Georg Dormehl, is literally the perfect way to understand the strict gatekeeping rules that hold our entire justice system together.
So it begs a really obvious question. Can you take your legal complaints directly to the highest court in the land? I mean, it's super tempting to think so. If you feel your constitutional rights are being trampled on, why bother trudging through the lower courts? Why not just take the express elevator straight to the top and demand justice from the ultimate boss? Well, as we're going to see through Mr. Dormehl's wildly ambitious legal adventure, the answer is a massive no. And honestly, the reasons why are absolutely crucial for keeping the whole legal system from just imploding.
Okay, so let's look at this DIY constitutional case and Mr. Dormehl's highly unorthodox application.
So Dormehl decided to just play his own lawyer. He bypassed all the usual channels and fired off an application straight to the Constitutional Court. Now, usually legal paperwork has super strict formatting, like very specific notices of motion backed by sworn affidavits. But Dormehl, he submitted what can only be described as a total procedural mess. In fact, Chief Justice Chaskalson used some wonderfully dry, very diplomatic judge speak in his ruling to describe it. He literally said it consisted of a mixture of arguments, averments of fact, and statements of the relief sought, which are not always clear or coherent. Basically, it was all over the place.
But here is where the court did something pretty incredible. They actually decided to just ignore those glaring formal defects and hear the case based on its actual merits. Because Dormehl clearly didn't have professional legal advice, Chief Justice Chaskalson felt it was only fair to look past the terrible formatting. The court basically gave him a pass, saying, all right, the paperwork is a disaster, but let's see what you're actually trying to argue here. They managed to distill his chaotic filing down into a few distinct legal challenges.
Which brings us to his first major hurdle, gate number 1, direct access, in his attempt at bypassing the lower courts. Dormehl essentially wanted to strike down what's called Rule 17. This is the rule that says you need the Constitutional Court's explicit permission to just knock on their door directly. He thought this rule was totally unconstitutional. But let's just think about the sheer logistics of that for a second. The Constitutional Court is the highest court of appeal. It's not designed to be the place you go first, because if you lose there, where do you appeal? Nowhere. Plus, it takes 11 top judges to hear a case in that court. Why tie up 11 of the country's top legal minds when a single high court judge, who, by the way, already has full constitutional jurisdiction, can easily handle it first? It just doesn't make sense.
This brings up a really crucial distinction. Dormehl was arguing that Section 34 of the Constitution says everyone has a right to a fair, public hearing before a court. In his mind, that meant he got to pick exactly which court. The judges firmly shut that down. Yes, Section 34 guarantees you a fair hearing, absolutely, but it does not give you a VIP pass to demand that hearing at whatever level of the court hierarchy you feel like. As long as a competent court is available to you, like the High Court, your rights are perfectly fine. Rule 17 isn't denying justice, it's literally just traffic control.
That takes us right into gate number 2, corporate and cost rules, and what the law calls the problem with abstract challenges. You see, Dormehl didn't just want to skip the lower courts. He kind of wanted to rewrite the rules on who even gets to speak in them. He targeted Rule 7.1, demanding that regular laypeople should be allowed to represent corporations in the superior courts. Specifically, he was trying to overturn an old 1964 precedent called the Dormehl's Garage case. That precedent established a hard rule. An individual human being can represent themselves, sure, but a corporation? That's a separate legal entity, so it absolutely has to be represented by a qualified legal professional. On top of that, he wanted to scrap the rules requiring litigants to put up security for court costs, which is basically proving you have the cash to pay the other side's legal fees if you lose. Now, all of these demands hit a massive brick wall because of a vital legal concept, the difference between an abstract question of law and a concrete dispute. Look, courts exist to solve real problems between real people. They aren't there to just answer theoretical brain teasers or grade a law on a hypothetical test. Mr. Dormehl was essentially just throwing a bunch of legal complaints at the wall to see what stuck. He was asking the court to declare these rules unconstitutional in a total vacuum, completely separated from any actual real-world conflict happening in that exact moment. The bottom line is this. If Dormehl really wanted to fight corporate representation rules or the rules about securing costs, he had to do it during an actual active trial.
And the why here is super important. It's all about fairness. If you're trying to dismantle a law that protects another party, like that rule securing court costs for whoever wins, that opposing party needs a chance to stand up in court and defend themselves. You just can't legally ambush a rule without giving the other side a voice to argue back.
All right, moving on to the final and honestly most dramatic part of the case. Gate number 3, the mandamus, where the applicant demands a written judgment.
So a mandamus is essentially a court order that forces someone to do their job. Here's the setup. 2 years before this constitutional court filing, a high court judge named J.P. Rue gave an oral judgment in a case that Dormehl was involved in. Fast forward 2 years to the present day, and Dormehl suddenly demands that this old oral judgment be transcribed, and he wants Judge Rue to personally revise and sign it. Well, the judge, very understandably, refused. He basically said he wasn't going to waste his time refreshing his memory on a 2-year-old case unless Dormehl gave him some compelling reasons. And guess what? Dormehl gave 0 reasons. Instead, he tried to use the Constitutional Court to literally force the High Court judge's hand. And this is where Dormehl hit another massive procedural roadblock. You literally cannot just sue a High Court judge because you feel like it. Under Section 25(1) of the Supreme Court Act, if you want to take legal action against the High Court judge, you have to get the explicit consent of that court first. It's a completely necessary layer of protection so judges aren't endlessly harassed by people who are unhappy with their rulings. Mr. Dormehl, yeah, he completely failed to get that consent. He just tried to barge right through the gate.
Which brings us to the climax of this explainer, the court's final verdict, and how they defended the boundaries of the justice system.
So, after patiently untangling all of Dormehl's confusing paperwork, shutting down his attempts to bypass the lower courts, rejecting his theoretical arguments about corporate representation, and pointing out the massive flaws in his attempt to sue a high court judge, Chief Justice Chaskalson and the entire bench handed down a unanimous verdict. Their conclusion? The application for direct access is refused. The huge takeaway for us here is that these strict rules aren't just annoying bureaucratic red tape, they are the actual load-bearing walls of the justice system. They make sure cases run efficiently, they ensure everyone gets a fair chance to argue, and they save the absolute highest court for the most critical, final constitutional battles.
I want to leave you all with a provocative thought to chew on. What do you think would happen to our justice system if the highest courts just had no gatekeeping rules at all? The Dormehl case paints a pretty vivid, chaotic picture. The whole system would instantly gridlock with confusing DIY applications, theoretical grievances, and random administrative demands. There would literally be no time left for actual concrete constitutional crises. So, understanding these gates doesn't just make us smarter about the law, it really helps us appreciate that delicate balance of fairness and efficiency that keeps the gears turning for everyone. Thanks for joining me for this explainer, and keep questioning how the system really works.